Good morning, guys. How is everybody today? I hope you had a nice evening last night, and I hope you're having a good morning this morning. Hi, my name is Debbie. Welcome to my channel. We are on part 17 of the Darrell Brooks trial. This is day 13. They are in the middle of the charging conference. Darrell is in the other courtroom building his box fort. Sorry, guys. Allergies this time of year is awful. Let's see what trivia Judy has. Judge Darrow ran for Wisconsin Supreme Court in 2022, but conceded after the primary. A month before the primary, Darrow was hit with allegations that her 19-year-old son was an active drug dealer in Milwaukee and that she had been aware of his activities. The information was revealed after the overdose death of a U of Wisconsin student who had been a frequent customer of Darrow's son. I knew there was something with her kid, but I didn't know exactly what it was. That's awful. That's horrible. Good morning, Judy. Good morning, Wiggles. Hey, Ozzy. Judy loves this case. Hey, Wiggles. I don't think life failed him. I think he just is an ornery, stubborn, defiant man. Hey, Carla. That just wants to do what he wants to do. And I don't think the meth helped that any. I think it messed up his head and made it worse. So, Carla, which name is your name? Are you a Carla or a Nina? Okay. I know YouTube likes to keep us on our toes. Now you're up. I asked you 15 minutes ago. Oh, okay. Hey, JJ. I have a real life AJ. A real life JJ. Just like on Criminal Minds, I have my own JJ. Bill. No, what? Are you kidding me? It is 8:04. I tried to get you out of bed 15 minutes ago.
As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless we, then the state also made a request as it relates to jury instruction 70. Which is found on page 65. So as it relates to this, the state is asking that I simply based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said At times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner.
StreamYard, it's too early for this crap. Belle agrees. You agree it's too early for this crap? You gonna yell at StreamYard for me today? Yell at it again.
Of any position on that, which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there to stay busy. I'm putting them there for a reason.
Mr. Brooks, do you have any position on the verbiage of jury instructions 70 on page 65?
No question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Conclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. Later will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me.
Well, he keeps saying, don't ask me any questions.
Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no.
He doesn't have to.
No response.
Now he's going to say, I didn't hear what you said.
Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point. So what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me. I haven't been able
Mr.
to
Brooks,
present
I'm going to mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented?
Just pull it up right now.
Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing
Right.
grannies.
Do you have the exhibit list, Madam Clerk? What are those numbers again? I wrote 141.
Correct. We're just looking for the extreme dance and dancing granny chart.
Grannies is 54.
54 would be the dancing grannies,
Okay.
And 33 is extreme.
and 33 is the extreme dance team.
141 and 33.
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
they were all admitted based upon it and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 152 regarding the view?
As I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions.
That
would be
was
my position.
my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions? He's not responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you giving me one final thing? I didn't consent to nothing that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir. Your objections noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you...
Jennifer, he decided he wanted to be his own lawyer, and he has done everything in his power since day one to delay the trial. So he has just been disruptive and ornery and defiant at every turn. He's objected like almost to every single question, and he doesn't use the correct objections. He just throws them out there to see which one will stick. He argues with the judge. He screams back at her. She will let him go on and rant for like an hour and not interrupt him. And then as soon as she starts talking, he starts yelling at her. It's just, and he thinks he's a soft sit. Like, apparently he met somebody in jail that told him all about the soft sit movement. So now he thinks he's a soft sit. Bye. Love you. So now he's doing the whole soft sit thing, and he keeps asking all of the witnesses who the plaintiff is. Do they know who the plaintiff is? And then when they say the state of Wisconsin, he says, is that an entity or a person? And then, of course, that gets objected to by the state. Yeah, he's just, he's not really a soft sit. This is stuff he just learned about in jail. It's just his way of, it's like his last hurrah. It's his 15 minutes of fame or whatever. Like,
wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
even during this time, though, you've been incredibly disruptive.
I can't say
at one point you were muted for an extended period of time and you were yelling so loud, sir, we could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no. So how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it. You can't just say, I'm gonna do this because.
Sir, but you also can't stall the proceeding. I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. And so those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take we'll do a 90-minute lunch break. So it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes,
Okay,
we can do that.
thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to until the handout of the verdicts, and then you can leave for lunch. Thank you.
Oh, he's back in the regular courtroom. This is a man who was never told no as a kid. And the thing that irritates me the most is the Bible, is the fact that he's carrying around the Bible and pretending to read it. You killed 6 people and injured 61 others. And you gotta act like this? Should have played guilt. He should have played guilty. Why are you shaking your head? There's no sound. Is she even in the courtroom yet?
Address that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to
objection
state
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't
the
have.
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you, but I feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
But based upon what conduct? Me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present
I
in
do
a
not.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand.
Well, then you shouldn't have fired your
I'm
lawyers.
not making a voluntary waivery of anything.
Are you willing to, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
The jury went
I do
home,
not
Marty.
understand the question you are asking.
Are you willing to,
The jury went home. They're doing the charging conference where they look over the jury instructions, and the jury won't be back until the next day for closing arguments. So you don't have to worry about that. He would. I'm sure he would if they were there, but they're not.
not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Given that he won't answer the questions directly, for now he is,
In this courtroom. Yeah, I told you I don't understand.
that's not answering the questions, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
You want
All right, let me start with the jury
You
instruction.
gonna
There
start
is
with,
one I would like
subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not going to address
Under
that
what
further.
law, under what lawful law?
Sir, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate
I
record.
just told you that I don't understand the questions you're asking. What do you want me to do?
Oh, he said asking right.
I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights are
doesn't
not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me
it
because I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't
understand
understand
that right?
anything. Nope, I don't understand. Nope.
Oh, you liar.
Then you're going to stay here for now.
And under what lawful law? You can't force me to stay somewhere that I'm making a request not to.
She absolutely.
You can't make me understand. You can't force me to understand what I don't understand. You can't force that.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do, and over talking you, as you state that I do.
now.
I'm making a request merely to not be present for these proceedings. Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today. I haven't even been allowed to present any evidence, which is something that I stated weeks ago. Weeks. You already knew, Your Honor, that I wanted things to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
Because you fired your lawyer. Stupid.
Questions this morning when this court went through the
Knock it off. StreamYard, what are
that I
you doing?
cited this morning. I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify on your behalf. I'm not going to revisit those, sir.
They weren't correct.
I understand you will
Because
disagree
I
with
never
that.
consented to it and I never answered something.
I understand
And
you
I
did
just
not
stated
consent
the
to
reason
that.
why I didn't answer, because I don't understand. You cannot force me to understand what you're asking me.
Through you didn't even talk over me repeatedly
That from the other morning, all morning.
to the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With rooms.
Your
The functional equivalent
to
of being
your
present in this
equivalent to
courtroom.
your equivalent is adequate, but to mine is not. Seeing as how you always state Illinois versus Allen, you always state that, but it never refers to a fourth option that you refer to. It never
Mr. Brooks,
refers
I'm
to
not going to
that.
debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring up
Allen,
subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm being
then
held
you
in
are
contempt.
frustrating the purposes of this hearing
I'm trying to
right
figure out
now,
why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've
Oh,
made?
she
They're not
Interrupting
they're
me.
not correct decisions, Your
I
Honor.
understand that.
I can't answer. You asked me. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make
You
a finding
wouldn't
based
shut
on
up
that.
long enough to
How
listen
is
to
that
the
lawful law?
question.
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying,
over
how
me,
can you do that without my
If you
consent?
continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
That's what you
I
want.
have requested to
I
be
just
there.
made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still.
also won't have a dialogue with me about your understanding
Because
of what that
it's my
means.
Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything, actually.
Actually, yes,
No,
you
you're
can.
right, but I can make certain findings that you forfeit rights
You
that
can't
you have based upon your
and based on
conduct.
what lawful law, Your Honor?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am
That I
moving
can
on.
be present from another courtroom.
I need
if I
to
forfeit
discuss
my right-
instruction 315.
Your Honor,
because
I don't
believe some language
understand.
needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force
Done
something
that.
upon me. That's
You
coercion.
know
Your
who
Honor.
would understand? A
Mr. Brooks, I
lawyer.
completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely
didn't.
uncooperative with court this
That's
morning.
because I didn't
and-
understand. I'm explaining why, Your Honor. I'm
and the
not
court
trying to
gave you
leave it where it
ample
was at.
opportunity to answer the questions.
I'm attempting
So I'm going
to
to go.
explain myself of why I did not answer. It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to
Exactly.
instruction 315.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling you I don't
do you understand
understand?
what that I'm asking you to be
No, I
quiet?
don't. No, I
Mr.
don't.
Brooks, please stop interrupting
And for the
me.
record, I don't consent to being called that name, Your
You
Honor.
clearly hear me, sir, because if you didn't hear me, then you wouldn't make that statement. So I
Hearing
know
and
you can
understanding
me.
is two different things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to interrupt you, but you're gonna, at some point, you're gonna ask me my opinion of what's going on, and then when I tell you I don't understand, it's gonna be taken as me trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will explain why I'm bringing up instruction 315.
And I'm not gonna understand your explanation.
Well, you can't say that if you haven't heard what I have to say.
Didn't you try to do this earlier, before lunch?
But I need to clarify something, because 315, which is the instruction that has it's titled, defendant elects not to testify. I had it in there. However, that instruction should really only be given if requested by the defendant. There's been no request made. And obviously this court made a finding that he forfeited his right to testify.
That's to your benefit.
And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury.
I did look at the notes that are associated with instruction 315, and I would agree.
Right. Mr. Brooks, do you have any position on whether this court should include instruction 315 in jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's
I don't-
entitled Defendant Elects Not to Testify. I'll read it for you. It's my notes, meaning my materials, my jury instruction book said, given only if requested by a defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand
The
what
jury
you're asking.
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never say
you
yes or no.
is,
I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because I
given
don't.
this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I
never
understand.
said-
I understand what you're saying, sir. I
never
really
said-
do.
It
But
doesn't
in light of the
matter.
court's decision that you forfeited your right to testify,
How did I
do
forfeit
you
something
want
I never
the
said?
jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do
Your
you
Honor?
want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based
I don't
upon there's
understand.
not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction, or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really
You really
what I would
shouldn't
describe
fire
as
your lawyer.
consistency and
That's all I
how
gotta say for you.
phrases,
I don't know.
whether there's all caps, not all caps, but
All caps.
what we call the sentence
Like the name that was
capitalization
on
for
there,
the
all
charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through.
Wiggles through me a squirrel, y'all. Walt Disney placed the garbage can. He had a hot dog. He ate the hot dog while he walked. And then when he was finished, he placed another trash can. And he threw the container, the wrap, whatever, the hot dog in the trash can. That's how he paced out where the trash cans go at Disney World or Disneyland. And that's why at all the parks, that's how the trash cans are paced. How long it takes to eat a hot dog.
Through all of that to be consistent. I want to make sure the word information is capitalized, since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So
Lady, it's not a law word.
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I go to the other courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not?
She said so.
I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
He said no.
Are you waiving your right to be present in this
I'm
courtroom?
not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You're the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case.
Yeah, and you haven't been impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and that
It's not about me
response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will
can't force
respond
me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to no counsel. I gave you the
waived your
contract.
right.
I did not. And you won't sit here and say that for the record, because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have do we have the
Your-
paperwork? Because I believe that I gave you the paperwork back that
Mr. Brooks, you
I
very
gave it to you altered.
clearly
It did not waive it.
have been presenting a nuanced argument regarding
That
the
is
right
not
to
true, Your
counsel
Honor. That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this courtroom.
I don't fully
I
understand.
disagree with your characterization
disagree with your
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety-
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions whatsoever.
You definitely do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying in open court on the record that I don't understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
Right, Mr. Brooks,
It
you
is
are
also my Fifth
interfering with
Amendment
the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
And
of the
yet
way
you continue
put it.
to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out. Make the finding and hold me in contempt, which is what you waiting to do anyway. That's why that courtroom been set up the way it has for the whole time, because at some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
No, it's not. It's nothing.
I stated from the beginning, sir, that the goals of this trial,
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what you
number
know?
one, sir, is during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you
includes
didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made, what is sometimes referred to in the case law as the ascertainment of truth. There's an equal but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I've sometimes referred to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
it?
with the
I can't
court
even make evidence.
decisions, sir.
Yeah, but how can
In
I defend myself if I can't even present evidence?
But sir, you have not been willing to follow the rules of civility
But
and
that doesn't
decorum
have
and
anything
trial.
to do with my evidence.
It has
I could have did that
everything.
from the other courtroom too, correct?
Sir, you
If I can be present from the other courtroom, I should be able to present evidence from the other courtroom as well.
and you, by your conduct this morning, sir, are
I'm
not
saying-
willing to
I'm saying-
answer the
I'm
most
saying
basic of
Totality.
questions
The
about
totality, Your
whether
Honor. The
you
totality.
had a witness
Have
available.
I not asked, in fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence.
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know that if you didn't ask me? Answer the
You,
question.
as your own attorney, you
To do with me
abundantly
being able to
clear.
present evidence.
So, Mr. Brooks,
Nothing
this is your
I
final
presented have
warning.
been able to be admitted into
I am turning
evidence.
to the state for a discussion of the verdict forms. If you interrupt me or them again, then you will appear from the neighboring courtroom.
You want me to
That's
appear
what he
from there?
wants.
I don't.
Just let me go.
Attorney Basie, go
Just
ahead.
let me go.
I felt that all the verdict forms looked good. I did ask your
This is
clerk.
ridiculous.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be
There
in
wasn't
recess
no
until
warning.
this
I'm the
taken
one that asked.
over
So let's
to the
Make the record
courtroom
correct.
and we
I'm
have
the one
the
that actually
audio
came in here, Your Honor.
and video working appropriately.
I
You
asked-
have to utilize the share screen in order for
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
the
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
He needs to be spanked. His mama didn't spank him enough growing up. That's his problem. He needs a good spanking. He's gonna act like a toddler. He got that in prison, didn't he?
Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, I think it was actually the day that a misspeed. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet, it just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again, for the record, the forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? You have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Or go find something to spank you with.
Teresa, you had the large packet of verdict forms. What were they? How were they given to Mr. Brooks prior to the lunch break? By hand to the.
There's a t-shirt on Temu that I want. It says Wooden Spoon Survivor.
Bailiff and the bailiff to him. To be. And the bailiffs are confirming that the verdict forms were provided to him on his table. I will remind you once again that I do, it is my practice to put all of the not guilty verdicts on top of the guilty verdicts in a collated fashion. Again, I saw a couple of just cleaning up, I would say, not with the words themselves, but just capitalization of various words within the verdict forms, and I'll make sure that's done. The appropriate counts had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through I believe 60.
It would be 7 through.
7 through 67 have that special verdict, and then the hit and run counts have the special question related to did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed, going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to read through all of the instructions up until the point of closing arguments, and then I stop. Parties are given their opportunity to argue the case to the jury, and then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict form specifically. And then, of course, the alternate jurors would be selected. But given...
Am I muted?
No, you're not. You haven't been.
So I got a question about the enhancer for use of a dangerous weapon. How is that being charged? Is that under 939.632?
It is in the charging document, sir.
How is that being charged? From my understanding, that the statute reads, the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged.
Thought he didn't understand.
Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State want to is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree of recklessly endangering safety charges, so counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah, how is the alleged defendant being charged?
So are you asking how, or are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how, that's why there's the question. Reading the statute.
And which part of this, I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632. How is that enhancement, how is the alleged defendant charged with that enhancement? And reading the statute, it says it, well, I just read it, so.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged.
Right, that's what I just read, Your Honor.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime? So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this alleged crime to transpire, and that would essentially mean the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon, because you can't have the crime of armed robbery without the threat or use of a dangerous weapon. And so
that's the same argument in this, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
It's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
I respectfully object to that, Your Honor.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Yeah, will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May I respectfully, in conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings indicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact?
Your request is not based in law or fact, sir.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter.
The court's already made its findings regarding the forfeiture of the right to present additional evidence and testimony. I'm not going to revisit.
Or did not
Understand.
want to testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir.
Way back in the beginning, if you remember, when she asked you the questions about being your own lawyer, she told you you were going to be held to the same standards. So all this I don't understand crap, I wonder if that's why he decided. I wonder if it really did have anything to do with the Sovset thing, or if he thought he was going to be able to say, "But I don't understand," and people would feel sorry for him and give him the answers and help him out. Because now he thinks he can just say, "I don't understand," and they have to bend over backwards for him. Because now he's like, "I didn't waive anything. I told you I didn't understand." Like it's his get out of jail free card or something.
Other than how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
That's what she
Sir, I
just
will
said.
ask you once more. Do you have
She's
any
good.
other issues
And I will
to
tell you
raise?
once more, I
with-
don't understand the questions that you are asking.
Sir, do you have any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
He has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
what law of
additional?
fact? Under what law of fact can you say no? When
Sir,
I'm
do
telling
you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That
verdict
is incorrect.
forms.
That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
All right, did the state have any other?
It is my
I'm going to mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow. So I exercised my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
Yes, we do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yep, I have questions related to all of them because I don't understand any of this.
My question was not, do you have questions, but do
And
you
my
have any
answer
requests?
my answer was I don't understand. And I've made several requests.
The requests are not
About-
related to the jury instructions, which is the phase of this hearing that
I
this
didn't-
court is attempting
I
to
didn't
conduct
answer-
with you and give
I
you the
didn't answer the
opportunity to
question.
fully participate. Mr. Brooks
You
is
did
choosing
not.
not to answer my questions.
You did not.
I'm going to mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions? I will about the jury instructions. I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this?
I think not that I'm on his side at all, because what he did was awful. But had he let a lawyer defend him, they could have gone with the fugue state defense. Remember we were talking about that a few days ago? Yeah, and the witness that he called, the girl with the long, like, light brown hair, she said he looked right through me. That could be a fugue state because you look at people, but you're not looking at people because you're out of it. There's so much a lawyer could have done, like a blind rage thing, because he had a fight with Erica and then he was in a blind rage. he did nothing to help himself. He only made himself look worse. And there's so much a lawyer could have worked with. Not that I'm defending Darrell, but I'm just saying his defense right now, he has no defense. He just has his own stupidity. And a lawyer could have done so much more with his case. He still probably would have been convicted, but it would have been a much more boring trial. But and we wouldn't have all this fun watching him. But a real lawyer would have done so much better. They had stuff to work with in this case.
This point as it relates to the jury instructions.
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
So do you have any
That's common
requests
sense.
for any additional instructions that are
Yeah,
not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions, and I told you this weeks ago.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook
specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you point me to a specific filing?
So you have all my filings on file? Are you saying that you have my filings and they haven't been admitted into evidence?
Oh, my computer's not working.
Oh, now the computer's not working.
Oh, you heard her say that under her breath.
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instructions.
Yeah, I didn't think about that.
You just said you was referring to the filings. Right? Did you just say that?
That's not what I said.
Didn't you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
It's being a little temperamental, but I just can't use my search function, so if you can direct me to a filing, that would be great.
It would also be great for those filings to be admitted into evidence.
Sir, simply filing something with the court does not make it evidence during the evidentiary.
StreamYard, y'all.
Those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have something in particular, sir,
I asked you to do your job.
sir, if you have something, a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this when it's clear that I don't understand?
Your Honor, I can inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So what jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as we all know, I didn't obtain the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests.
I didn't say
And
that.
they will be
I said I don't
approved.
understand.
They will be
You
approved
can't-
and are,
No.
I'm gonna have to mute
No.
him. They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct. And provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consider being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how they allow it to pass just because you feel that they should. When I'm telling you I don't understand them.
I would note that
No.
his...
Not one of those jury instructions came from me. Not one. How's that fair?
Mr. Brooks, this court gave you the draft
didn't
of
give
the
me
jury
anything.
instructions.
You didn't
I
give me
need to
anything.
mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals, and the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the 3 alternates once they have been selected. It would be our request, the position, that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case, so that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the 12 who are deliberating, if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address?
She's referring to me.
You are unmuted. I am.
I just told you, since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if
it's gonna
appropriate.
be a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed, you just been making all the decisions for me, even though I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
You made the
Are you
decision.
telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy,
If it ain't-
civility,
don't-
the rules of evidence, and
don't try to come with
rules
your
of
slick
procedure?
words. Don't try to come with your slick words, and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the integrity.
You've been slick. You've
All right.
been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful.
I don't care.
I
what
need
you
to
think.
go
I don't
over
care
these.
what you think.
All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many pages of jury instructions and verdict forms to just make sure they aren't addressed first thing tomorrow morning. But then I do intend to start with a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument, and so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Madam Clerk, can I see the instructions that we have thus far? The packet?
It should be done and printed.
Okay, thank you.
Single side.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning, because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
I didn't realize.
I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, Your Honor. and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for your any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Do you?
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm
Given,
not doing it tomorrow.
then you'll forfeit your right to give one, sir. Because as we have,
You can't force me. You can't force me not. What type of court is this where you can say you're going to force somebody not to be able to give a closing argument? How's that lawful law?
sir, if you choose me right now, which is incredibly disrespectful once again,
Okay.
You didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Change your incorrect record. Go ahead.
I'll
Why
move
does
once
she
again,
ask?
because clearly
Let her
he just wants to be
answer.
disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. Hour each, I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That will be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
So then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws they don't agree
You
with.
are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is
Show me
not
where
your
it's at.
right to raise
Show
jury
me-
nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table.
If a lawyer were to bring that up to a jury, that they can nullify the verdict, meaning they could find someone not guilty even though they know that they did it. If a lawyer were to get up and mention that in closing arguments, they could be held in contempt. They could go to jail for that. And I think they could also be in trouble with the Bar Association, although I'm not positive about that. But I do know that they could be held in contempt of court for doing that, because that's not legal. You are not allowed to tell a jury that they can nullify the verdict. And he's going to try it. They can't be disbarred. Okay. I didn't know if that was... I thought so, but I wasn't 100% sure. But I do know they can be held in contempt. The judge can hold them in contempt if they do that. It's a big no-no.
It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need
Nice try.
a very
Thank you.
clear
Seated.
pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And that is You are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to, due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on how, is it late at night? Is it during the day? You know, are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider kind of, you know, the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the state for victims.
Okay, and the other side,
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you
My
wanna think-
previous, or my rule throughout has been 15 minutes. What I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side,
Okay,
if that's what you're asking me.
yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but, I don't, how can you deprive me of my constitutional rights? How can you trample on my constitutional rights?
Come here and land it on your back.
How?
Come here. Like it's on your
Sir, you
back.
can forfeit a number of constitutional rights by misconduct on your part.
Not if I reserve my rights, you can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
going
versus
to hear that.
Arkansas,
It's
State
on-
versus Anthony, Illinois
Did they
versus
reserve their
Allen,
Did they reserve their rights?
Right. Come
the
here.
Beneby decision. There's a host of case law, sir.
It's
Did
on.
they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I had a few
Go
other.
ahead.
Come
You
here.
do. I'm sorry, go ahead.
Come here.
I just wanted the record to reflect that at about 2:04 PM, your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury instructions?
Shush.
Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
Lord, what a crazy.
Were all jurors, or will all jurors then be told to report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving, I'll get you in a second, that he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't think I need a PSI. This is a trial. This is not like a guilty plea. So, Mr. Brooks, I'll get you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court places in evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to?
When they decide to fire their lawyer and represent themselves, they have to go through a series of questions, and the judge decides if they're competent enough to be their own lawyer, I guess. It's not like a mental eval. They just have to be able to read and write and understand questions and be able to represent themselves. So I guess maybe Manson was found not able to do that, whereas Brooks was. It would have been nice if he hadn't been able to answer the questions and they could have kept him with a lawyer. No, it wasn't a competency hearing. It's just like questions and answers with the judge. Because if he had failed a competency hearing, then he wouldn't have been allowed to go to trial at all. I know. And I don't get to eat because I'm talking. So a competency hearing would have made them delay the trial. Because even though they're not representing themselves, they still have to be able to assist in their defense. So if they pass a competency hearing and they're fit to go to trial, but then they want to defend themselves, then they have to just go through like a question and answer session with the judge. And then the judge decides if they are competent enough to represent themselves. So it's not really like a mental thing. It's, do you have the intelligence and understanding to be able to like read and write and look up laws and figure out how to ask questions to people and object, like, and the judge just kind of guesses by the questions and by talking to them if they're able to do that. So apparently in Manson's case, the judge decided he wasn't able to do that. But with Darrell, and he'd already had some kind of outburst and fell asleep when he had lawyers. If it'd been me, I wouldn't have let him, but I didn't know that Manson wanted to represent himself. That makes sense because he was definitely a narcissist. I mean, he thought he was Jesus, right?
Yes, sir.
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says
right
you have a
under the-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So-
general arguments that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
Okay, guys. He is still yelling, but he's muted. And that's the end of the day. The camera's still on him, though, and there's no sound. Okay, hey, Ken, you missed a lot of insanity. So, do you guys want to stay with Brooks? Or do you want to go to, I know. That's all. It was just him. It was no sound. It was just him taking off his mask and yelling and then putting his mask back on. Do you guys want to stick with Brooks, or do you want to go to the closing arguments of Amber Alert murder? I mean, we can do closing arguments of that later, or we can do closing arguments. Okay, we got 3 options again. You want to go to closings? Because we also have the trial that started yesterday, too, that we can do. Or we can go back to Darrell. Closings? Okay, closings. Okay, so we're going to go to the other stream. Oh, did I? Oh, I didn't set it up to redirect. Did I? I might have. I don't know. I guess it'll be a surprise. Okay, I'll see you guys over there. I cannot remember if I set it to redirect. I'm sorry. Because I did this yesterday. So, if it doesn't redirect, just find me. Okay, I'll see you in a few minutes, guys.